Welcome everyone to our Friday morning seminar. Don Stemen is going to be presenting. Dave Olson will be sort of present and presenting. He's in the crowd. And so we're going to be hearing about cash bail reform. So Don, take it away.
Sure, thank you. Hi everyone, my name is Don Stemen. I'm an associate professor and chair of the Department of Criminal Justice and Criminology here at Loyola. My colleague, Dave Olson, who's here with us, he's at jury duty right now, but he may jump in to correct me if I say something incorrect every now and then. But Dave Olson is a professor in the Department of Criminal Justice and Criminology. He's also the director of the Center for Criminal Justice Research Policy and Practice here at Loyola. And the project we're going to talk about today is a project we did with funding from the MacArthur Foundation Safety and Justice Challenge Research Consortium, which is a really long title of a funding agency. We got funding from them about 18 months ago to look at bond court reform in Cook County. So what we're going to talk about today is some of the findings from that and some of the next steps around bond reform or cash bail reform in Illinois. So I'm going to go ahead and share my screen. Make sure everybody can see that okay? Good. Yep. All right, good. Good. Before we start, I just want to give a little bit of background around bail in the United States. So I don't know if everyone's familiar with how bail works in the United States or what happens to individuals after they're arrested and potentially held in jail. So oops, there we go. Just this is a quick primer on bail in the United States. So in most jurisdictions in the United States, once a person's arrested, they go before a judge and a judge determines whether they're going to be released and if they're going to be released, how they're going to be released pending their trial. There are generally three decisions or three outcomes that a judge can come to in that initial, what we usually call bond court hearing. A judge could release an individual on their own recognizance, meaning that the individual is released without having to post any kind of monetary bond. They leave with a promise that they'll return to court for their upcoming trial or any court hearings that happen before trial. Or a judge can impose monetary bail, meaning that the person would have to post some kind of cash or a bond to be released from jail before their trial occurs. In Cook County or in Illinois, that has to be money posted by the defendant or their family themselves. In other jurisdictions, they have bail bondsmen that will post the money for an individual with collateral put down. In Illinois, we don't have bail bondsmen here. People have to come up with the money themselves to be released before trial. The idea behind monetary bail is that it ensures the person will return for their court hearings. So the idea being that if a person posts some kind of collateral, whether it be cash or some kind of property, that they'll return for their court dates to get that money back, right? And the idea is it ensures that people don't skip out on their court hearings. Judges can also hold people pre-trial through what's generally called preventive detention, meaning that the judge can decide that this person should not be released into the community before their trial. They should be held in jail until the resolution of their case. Excuse me. Right. These are generally the three outcomes that can happen in a bond court hearing. Whoops, I don't know why that doesn't advance. There have been many calls for bail reform in the United States. Specifically, proponents have advocated for eliminating monetary bail, or at least changing its practice because it disparately impacts poor defendants, right? Even small amounts of cash bail are hard for many defendants to come up with, and people end up being held pre-trial in jail simply because they can't come up with the money to post to be released. Opponents of bail reform counter that eliminating cash bail would increase failure to appear rates. That's what we call when people don't show up for their court hearings while on pretrial release, and that will increase crime. right? Because with more people out in the community, the argument being they will commit crimes pending their trial. So bond court reform or bail reform in the United States has taken off in the last few years. There's a lot of talk now about eliminating cash bail around the country. We'll talk about at the end how Illinois has passed a law recently to do that. Other states and jurisdictions have as well. So Philadelphia, the Philadelphia District Attorney's Office a couple years ago eliminated cash bail for a large number of offenses. They no longer requested cash bail. New Jersey did away with cash bail several years ago, and New York State significantly reduced the use of cash bail in the state. Evaluations of all of those reforms show that the elimination of monetary bail increased the number of people being released pre-trial, and it had no effect on crime rates in those communities. What we wanted to look at was in Cook County, right, so Cook County engaged in a form of bail reform several years ago. So in 2017, the chief judge of the Circuit Court of Cook County issued an executive order, general order, establishing a new decision-making process in bond court in Cook County. And really what was to happen were judges were first supposed to determine whether a defendant should be held pre-trial, and if so, hold that defendant in jail. So impose preventive detention if a defendant should be held pre-trial. However, if a defendant could be released pre-trial, there was a presumption that the defendant would be released without having to post any kind of monetary bail. So the presumption in Cook County would become the use of ROR, release on recognizance. In Illinois, we call it I-bond, which just means the person doesn't have to post any money to be released. However, if a judge felt that some posting of monetary bail was necessary, the judge was supposed to set bail at an amount that the defendant could afford. Right? Generally, in most places, there's no assessment of the affordability of bail for defendants. Judges can set it at whatever amount they want, regardless of whether the defendant could actually pay it. This general order in Cook County said, no, if you're going to impose monetary bail, it should be at something that defendants could afford. The expected impact of these reforms would be to increase the percent and the number of defendants released on their own recognizance, so released without having to post any kind of monetary bail, and a decrease in the bail amounts for those defendants who did receive some kind of monetary bail. So immediately after this went into effect, the Chief Judge's Office planned to do an evaluation. So in 2019, they did it, I think that's what it was. They did an evaluation of bond court or of these reforms in Cook County, and the Chief Judge's Office found that it did indeed increase the percent of people released without having to post any kind of monetary bail, and that it in fact had no impact on crime rates, at least of those who were released, right? The idea that those who were released pre-trial, they didn't engage in new criminal activity while on release. There were a lot of criticisms of the Chief Judge's report about the methodology that they used for tracking people after during the study, right? That they didn't have very long follow-up periods, that they didn't track people before and post reforms for the same amount of time. And there were a lot of critiques of that evaluation. So we were asked by the MacArthur Foundation if we would do an evaluation of those bond court reforms, if we would take a similar approach or a different approach than the Chief Judge's Office did and compare a group of people released before the reforms to a group of people after the reforms who went through bond court. So that's what we did. So using data from the Chief Judge's Office on bond court decisions made by defendants who came through bond court in Cook County and court data from the circuit court, and then jail data on who was admitted and released from the Cook County jail. We created two groups of defendants, what we called a pre-reform cohort. So a group of felony defendants who came through bond court between November 2015 and April 2016. That's before the reforms went into effect. And we compared them to a group of defendants who came through felony court after the reforms between November 2017 and April of 2018, a post-reform cohort. And our idea was to compare these two groups to each other, to look at what was happening in bond court or what kind of bond court decisions were imposed. And then if people were released, whether they were charged with new criminal offenses while on pretrial release. We followed each one of these groups for 12 months after their bond court hearing date or until their case was disposed, whichever came first. So for those who went through bond court between November 2015 and April 2016, we followed them through the latest about April 2017, which would be 12 months after the last group went through bond court. The same is true for those who went through bond court in the post-reform period. We followed them for 12 months. So that last group who went through in April of 2018, we followed them through April of 2019. And we were looking at 5 outcomes here in Cook County. The initial bond court decision. So whether the judge imposed ROR, some kind of monetary bail, or held the person in preventive detention. We then looked to see of those defendants who was actually released pre-trial, excuse me, right? So even those who have, so those who are released ROR were all released. Those who had monetary bail imposed, some of them were able to post bail and be released. Even some people who were held in preventive detention at some point in time may have been released from jail pre-trial if, say, there was a change in their bond court decision, right? A judge may have imposed monetary bail at some later date. And for those who were released, we looked to see if they failed to appear in court at any point in time during their pretrial release, and if they had a new criminal case filed against them in Cook County during that follow-up period. So either before their initial case was disposed or within 12 months of going through bond court. And if they had a new violent criminal case or one that involved a person offense, we followed that too to see if those who had new criminal cases, how many of them were engaging in some kind of violence. So that's the approach we took. So this was to correct some of the methodological problems that we saw in the chief judge's evaluation that had different follow-up periods for the pre and post-reform groups. It followed them for different parts of the year. So we know that there's some seasonality and when people do get arrested, right? Crime goes up in the summer. So if we only follow people through the summer months, they'll likely have higher failure rates than if we only followed people through the winter months. And not a good attempt to like match people to see if they were similarly situated before and after the reforms. So are there any questions on either bail reform or how we approach this?
Doesn't appear so. I think you're good.
I'm good. Okay, I'm going to go ahead then and we'll jump in. So the first outcome that we wanted to look at was this initial bond court decision. So, right, the chief judge's order set up a decision-making process where the judge was first supposed to determine whether or not the person should be held pre-trial. And if not, there was a presumption that the person would be released on their own recognizance. So the first thing we wanted to do was actually look at trends in outcomes in bond court. So how often were people getting ROR, monetary bail, or being held pre-trial? What you see here are just trends over time. These are simple descriptive statistics about what was happening in bond court, both before the reforms went into place and after the reforms were put in place. The line in each one of the charts kind of represents the time when the reform went into place, September of 2017. So I think you guys can see my cursor. If you look at this ROR chart in the upper left, what you see is like before the reforms went into effect, right? The use of ROR in felony bond court in Cook County hovered somewhere around 30%. About 30% of defendants were getting released on their own recognizance. Immediately after the reforms went into effect, that jumped up. Although this does show that it started to decrease over time. Initially, after the reforms went into effect, the use of ROR was relatively high and then declined over time. The use of cash bail, right, had been hovering somewhere around 50% before the reforms went into effect and immediately dropped right after the reforms down to about 20%. But again, showed a pretty good increase over time. So the reforms had an immediate effect on the use of cash bail that kind of dissipated over time. I didn't talk much about electronic monitoring. We're not going to talk about it here, but it's used in Cook County where a person is put on some kind of electronic monitoring where it monitors where they are at all points in time while they're released pre-trial. That requires defendants to post some kind of money to be put on electronic monitoring. It decreased after the reforms went into effect, but if you've read the newspapers lately, it's used a lot right now as Cook County tries to reduce the jail population during COVID. The other thing that's interesting here is that the use of preventive detention actually went up after the reforms went into effect. The judges were using preventive detention to hold defendants who they felt could not be released pre-trial. It went from about 4% to about 9 or 10% after the reforms went into effect. So judges were making use of preventive detention more often. So our interest is then in trying to understand what really happened after the reform. So again, we took a cohort of 6 months, a cohort of people who went through bond court before the reforms went into effect and compared them to a group of people who went through bond court in 6 months after the reforms went into effect. And what we do is then we control for differences in cases. So we control for we account for defendant demographics, age, gender, race. We account for differences in the cases, so the severity of the charges that a person faces and the number of charges that they're charged with, and we control for like risk that people pose. So the courts are required to do a risk assessment, which assesses people on their risk for failure to appear or their risk for new criminal activity, and we control for that risk as well. And then we try to compare those two groups and we look at what we call predicted probabilities. We try to understand, after accounting for all of those different factors, what percent of people would be released from jail. And when we do that, and we looked at this predicted probability of receiving release on recognizance, before the reforms went into effect, about 25.5% of defendants were expected to be released on their own recognizance. After the reforms went into effect in their comparison group, about 57% of defendants were expected to be released on their own recognizance. So a significant increase in the percent of people receiving ROR in Cook County. If you want to think about it the other way, a significant increase in the percent of people who don't have to post any kind of monetary bond to be released from jail pending trial. When we think about how many people that actually affected, about 3,500 additional defendants received ROR after the reforms went into effect who would not have received ROR before the reforms went into effect, right? So of the 11,000 defendants who came through bond court after the reforms in our sample, about 2,900 of them would have received ROR before the reforms. And what we found was about 5,400 of them received ROR after the reforms went into effect. Excuse me. Right, so a significant increase in the number of people who don't have to pay any kind of monetary bond to be released from jail. For those of you who are statistics averse, there are only going to be a couple slides that will annoy you. So these are the results from a logistic regression model. What this does is try to predict ROR, and this is accounting for all these different case factors. And what it does is it shows you a change in the odds of receiving an ROR. So everything that's on this side of the zero shows that it increases the odds of a person receiving release on recognizance at bond court. Everything on this side of the zero, negative numbers, would indicate that it decreases a person's odds of receiving ROR at bond court. So you can see the significant impact of the reforms, right? It significantly increased the odds of receiving ROR. We kind of saw that in a jump in the percentages or the predicted probabilities of receiving ROR. There's a couple things to point out here that are kind of interesting. One is the effect of defendant demographics. Men are much less likely to receive ROR at bond court relative to women. Older defendants are more likely to receive ROR at bond court relative to younger defendants. There are limited effects of race. Hispanic defendants are slightly more likely to receive ROR at bond court, but there's no difference between Black defendants and white defendants in the likelihood of receiving release on recognizance at bond court. This is looking at the whole sample together. This is looking at both the pre and post reform cohorts together. One thing to notice here, and I'll just point this out this one time, is so these are the scores for pretrial risk assessments that every felony defendant receives when going through bond court. And what's this showing is that the higher the risk, the less likely the person is to receive ROR, which is exactly what you want it to show, right? Which shows the risk assessment tools seem to be good at predicting whether or not someone's going to be released. So it shows that judges are actually relying on the pretrial risk assessment tools. The other thing to notice here is the effect of case level factors. So what's this showing is, so for example, the offense types, these are compared to people who charged with property offenses. So what you find is that individuals charged with a person or a violent offense are less likely to receive ROR compared to a person charged with a property offense. Same is true for weapons offenses as well. So what you're seeing is people charged with more serious crimes, violent or weapons offenses, are less likely to receive ROR, which is what we would expect. Drug offenders are more likely to receive ROR. And these show that the more serious the felony charges, the more felony charges that a person faces, the less likely they are to receive ROR. This kind of matches what the literature shows, right? That men are less likely to receive ROR, that more violent cases are less likely to receive ROR, or more serious cases than less serious cases. What we wanted to do is break this out, though. We wanted to look at what predicted ROR before reforms and what's predicting ROR after reforms. So the first thing to notice is the effect of race. Before the reforms went into effect, there was no difference in the likelihood of receiving ROR between white defendants and Black or Hispanic defendants. However, after the reforms went into effect, Black and Hispanic defendants were more likely to receive ROR relative to white defendants. What's interesting about this is that the reforms themselves had nothing to do about race, right? They were not targeted to reduce racial disparities in bond court decision-making, but simply telling judges that you should presume to impose ROR on defendants and only impose monetary bail when it's absolutely necessary had this racially disparate impact that Black and Hispanic defendants now were more likely than white defendants to be released on their own recognizance after these reforms went into effect. When we look at that outcome on broken down by racial and ethnic groups, excuse me, you can see that it went up for everybody, but it went up more for Black defendants than it did for white defendants. And you can see here post the reforms that the probability of receiving ROR is higher now for Black defendants relative to white defendants. So, and if we look at the actual numbers of people who are affected, again, one thing to remember is there are huge racial disproportionalities in who's arrested in Cook County. Black defendants, there are far more Black defendants who come through Cook County's criminal justice system than white defendants. So even though we see these rates are fairly similar, right? And the increase is fairly similar between white defendants and Black defendants, it affects far more Black defendants than it does white defendants, right? Nearly 4 times as many Black defendants were affected by this reform than white defendants. Now, are there questions now? I'm willing to stop after each little section if you have questions. No, we're good. Nope.
No, I think we're good.
All right, good. Happy to keep going. The next thing we wanted to look at was trying to estimate the actual dollar amount of bail costs avoided in Cook County. So if you recall, the reforms that the chief judge put in place was first to create this presumption that people would get ROR if they were eligible for release. And then if monetary bail had to be imposed, that bail would be set at an amount that people could afford. So we looked at the average bail amounts before and after the reforms. So average bail amounts in Cook County decreased from about $9,300 pre-reform to about $3,800 post-reform. That's the actual amount people have to pay to be released from jail in Cook County, right? So the average person before the reforms had to come up with about $9,300 to be released from jail. It's incredibly high, right? And it's a lot of money for a defendant and their family generally it's defendants' families who have to come up with this money to get someone out of jail. So if we think about how this really affected people, right? So there were 3,200 individuals roughly who received monetary bail after the reforms. They had to pay about $5,500 less to secure their release after the reforms went into the place than they would have had to post before. So, right, it's the difference between these two amounts is what they're saving. Those 3,500 people who got ROR after the reforms who wouldn't have before, they also avoided having to pay that $3,800 bail, right? Because they received ROR after the reforms. So if we think about what this adds up to, right? The reforms saved defendants about $31.4 million in avoided bond costs in just the 6 months that we evaluated after bond reforms went into effect, right? That's about $18 million saved by defendants just in the lower cash bail amounts, and about 14 million saved by those defendants who received ROR instead of cash bail. In Cook County, the cash bail amounts are not the same across racial and ethnic groups. So before the reforms went into effect, Black defendants were paying on average about $9,600 in bail to be released, compared to about $6,800 for white defendants. Hispanic defendants were paying nearly $11,000 in bail. You can see post reforms, these are much closer together in the amounts that people have to pay, but the largest reductions came for Black defendants and Hispanic defendants. When we think about the disproportionality of people coming through the justice system, again, there are far more Black defendants coming through the system than white defendants. The amount of money saved in communities of color is much higher than it is in white communities. So these changes in bail amounts saved Black defendants about $21 million in avoided bond costs, compared to about $3.6 million for white defendants and $6.5 million for Hispanic defendants. So when we think about the neighborhood level effects of bond court reform in Cook County, right, we're saving the communities of color, at least Black communities, saved about $21 million in avoided bond costs, right? Bond costs that are money that those families and communities can use for rent, food, medical expenses, right? All of that now stays in the community, when in the past it would have gone to the clerk's office and been held while the person was awaiting trial. Questions now? Anyone? We're good? No, all right. Right, so significant changes in the use of monetary bail and significant savings to communities after these bond court reforms went into effect. The other question we wanted to know is, did it change the number and percent of people being released pre-trial, right? Because while we may increase the use of ROR, if people were still able to pay their monetary bail before the reforms, a lot of them might have been released anyway. So we wanted to see how did release really change after reforms went into effect. So again, after we account for differences in case factors, we find that the predicted probability of release did not change that much. It went up, but it didn't go up as dramatically as, say, the use of ROR might make us think. Before the reforms, about 77% of people were released pre-trial. After the reforms, about 81% of people were released pre-trial. If we think about how many people that affected, right, of the 11,300 people who went through bond court after the reforms during our study period, about 500 more of them were released pre-trial than would have been released before the reforms went into effect. So while a dramatic increase in the use of ROR, this isn't a really big increase in the number of people or percent of people who actually were released pre-trial before and after the reforms went into effect, right? We would expect about 8,700 people to be released before the reforms. What we saw was about 9,200 people actually released in the 6 months during our study. when we look at what's predicting or what factors affect it, we can see there was a significant impact of, although it's only a 4 percentage point change in the percent of people who are released pre-trial, the reforms did have an impact on that, right? A significant impact on the likelihood of being released. A couple other things to notice here is that while defendant race increased the likelihood of receiving ROR, Black defendants were actually less likely than white defendants to be released pre-trial. Again, there's still the use of monetary bail happening, and what might be happening here is two things. One, judges did increase the use of preventive detention that might be disproportionately impacting Black defendants, so that more of them are being held in preventive detention. Also, the monetary bail, while it is imposed, may still be outside the reach of many Black defendants, and there may be a racially disparate impact of that, of monetary bail still, even though it's gone way down. It still may be at a level that many Black defendants can't afford, which is leading to this racially disparate impact. When we look at it pre and post reform, when we break those two groups out and look at what factors are affecting release, this racial effect is there in both the pre and post reform eras, right? And it's actually gotten a little bit bigger post reforms, which is surprising given the increased use of ROR. So when we think about the differences in the predicted probabilities of release, and we kind of break that out by different racial ethnic groups, we can see that it went up for everybody. And in fact, these still aren't that different, right? The difference between white and Black defendants post reforms is not that different, but it's enough of a difference that just the defendant's race alone decreases the likelihood of being released after controlling for all other factors in the case. So the big takeaways from this first part of our analysis are a couple things, right? So the reforms that went into place in Cook County didn't really change the number or the percent of people released pretrial, right? It went up from about 77% of people released pretrial to about 81%. Our estimates say that's only about 500 additional people who were released pretrial during that 6-month period that we studied. So the reforms didn't really change the number or percent of people who were released pretrial. It changed how they were released, right? It increased the use of release on recognizance, decreased the use of monetary bail. So it really didn't, it just changed how people released. People didn't have to come up with money anymore to be released pre-trial in Cook County. What also happens, the reforms significantly reduced the financial burden on defendants and their families, right? About $31 million in avoided bond costs to defendants who went through the bond court during our 6-month study period. And about 27 million of those avoided bond costs were in communities of color, right? So significant savings to those communities. I see somebody has a question in the chat. Oh, it's a comment more than a question, so I won't answer it. We can. I'll think about comments later. I'll just say this about monetary bail too, which a lot of people don't know. In Illinois, outside of Cook County, once a person posts bail, the county keeps 10% of it as an administrative cost. So even if a person is acquitted, even if a case is dismissed after a person is post bail, the county still keeps 10% of that. So if a person has to post $10,000 in bail, the county will keep $1,000 of that in administrative costs. Cook County changed their approach a few years ago where they'll keep $100 of the bond court, of the bail that's posted rather than the 10%, which significantly increases the amount of money that families potentially could get back. However, what people don't know in Illinois is also that any bail that's posted to the county, it is used to pay any other fees that the person might incur during their case before the person gets the money back. So if a person posts $5,000 in bail, the county will keep $100 of it, but that $4,900 that's left over will be distributed to any other costs that the person has incurred during that pretrial release period. So that would be any court costs, if there are costs associated with drug tests or electronic monitoring while they're out, all of those will be taken by the county before the person is given their bail back. So people could actually post bail and then have to owe more money at the conclusion of their trial if those bail costs don't cover all the costs that they've incurred. Oh, someone has their hand up.
And in addition, can the clerk's officers, whoever holding all of the bail funds, can't they invest those funds and keep all of the proceeds from the investments?
Well, that's a good question. I don't know what the county does with it. I'm sure they don't just like keep it in a drawer. Yeah. Does anybody know? Dave might know what the county actually does with the money. He knows a lot about county budgets. If he can talk while he's on jury duty. No. Dave did post in the comments, though. It's just important to keep in mind, right? That's not the county or the government's money. It's the defendant's money, right? So we have to think about how we think about that money. It's not a tax refund when you get it back. It's your money that the county's just been holding on to during that time. Exactly, to your point, if it is put into some kind of interest-bearing account, then who gets the interest? It sounds like it would likely be the county. Mina, go ahead.
Hi, thanks. I just had a question about, is there other kind of financial measures that could be used as well? Like, I know your data is your data, but I'm thinking not even only avoided bail costs, but avoided like job loss wages or some other kind of keeping the money in the communities.
Yeah, totally. And we don't even account for these things, right? So with the decreased use of monetary bail, the increased use of ROR, people spend less time in jail. They're released at that initial hearing. That means there's less job loss potentially by individuals who aren't missing work because they're being held pre-trial for potentially days or weeks before they can come up with the bail. Housing, right? People aren't losing housing potentially because of this too. If a person has to sit in jail for a month before they can make bail, during that month, perhaps they weren't paying their rent either, and they may be evicted, right? There are all kinds of associated costs that come with this that we don't even account for. Here, we're only accounting for the avoided costs that they have to pay to the county to secure their release. There was, yeah, Marilyn asked about the effects on new criminal activity. That's the next bit. So let me get to that now, and then we can come back to I don't think there were other questions about that in here. Yeah. So the other thing we wanted to see, and the big argument against bond court reform, right, is that the increased use of ROR and the decreased use of monetary bail, the first thing people argue, it'll lead to failures to appear in court. The logic behind monetary bail historically was that if we require people to post some kind of money or collateral to be released from jail, they will come back for their trial in order to collect their money and the collateral. So we're very concerned that if we don't make people do that, they'll just won't show up for court. So the first thing we look at is failures to appear. The second argument by opponents of bail reform is that releasing more people into the community pending trial will lead to new criminal activity, that those people while out on release will engage in more crimes. One thing to keep in mind, making somebody pay money bail to be released has nothing to do with whether or not they're going to commit another crime while on pretrial release. An incredibly wealthy person who can come up with money to be released doesn't ensure that they won't commit crimes while out on release. A poor person who can't post bail doesn't mean that if released, they would have committed crime. So we wanted to look at these in Cook County as well. I'm just going to show the predicted probabilities here for these. What we found was that reform slightly increased the probability of a person not coming back to court. So failure to appear rates increased slightly from about 16.7% before the reforms to about 19.8% after the reforms went into effect. This is after accounting for differences in defendant demographics and case level factors. So there's a slight increase of about 3 percentage points in the number of in the probability of people not coming back for trial. However, there was no impact, and I'm sorry, this was also if they had missed any one meeting, one court appearance during that 12-month period. And if you're familiar with Cook County, there are continuances happen often in cases. People's cases are continued every 6 weeks. So it's possible that during that time in a year, their case could have been continued 4 or 5 times. What we're counting is just if they missed any one of those court appearances during that period of time. So this is a pretty conservative. I'm not sure how you'd say it. We're accounting for any missed court appearance. This doesn't mean that, and we don't know if that was willful failure to appear, meaning that the person did just flat out, well, I'm not going to trial, or whether it was something else. They were late. There was a transportation issue. There was a childcare issue. And whether or not this was an excused absence. We're just counting whether or not they didn't show up. So a slight increase in failures to appear. There was no change in new criminal activity. So the way we counted new criminal activity was whether or not a person had any new case filed in Cook County between when they were released from jail and the termination and the disposition of their case, or 12 months later, whichever came first. So what we found was before reforms and after reforms, about 17% of individuals were charged with a new crime during the outcome of their case while they were released pre-trial. Only about 3% were charged with a new violent crime while on pre-trial release, right? So it's very rare that a person while out on pre-trial was charged with a new violent crime while released, about 3% both pre and post reforms. What most people were charged. So if we think about this in the big scheme, right, 83% of individuals released pre-trial had no new criminal activity during their release, right? So the very large majority of people who released pre-trial in Cook County during our study period, both before and after reforms, had no new criminal activity. Those who did have new criminal activity, most of them were charged with drug offenses while on pretrial release, or some other offense, usually a property offense or some criminal traffic offense that would that they were charged with, right? Only 1% were charged with a new weapons offense, meaning possession of a weapon, and only 3% were charged with a new violent offense, right? So the large majority of people who are committing new crimes while out on pretrial release are nonviolent crimes, property, drugs, and public order offenses or criminal traffic offenses. When we think about what's predicting this, again, this is a pretty rare event. So we're trying to predict something pretty rare here. It's only happening in 17% of cases. The reforms had no impact on new criminal activity. You can see that in the predicted probabilities, but there was no change. Essentially, there's no difference in new criminal activity before and after the reforms in the two groups that we studied. What is interesting is the pretrial risk assessment tool seems to be doing what you'd expect it to. Those defendants who had higher risk of new criminal activity or failures to appear while on release had higher likelihood of new criminal activity and failures to appear on release. So the pretrial risk assessment tool is doing what it's expected to do. We see some other things here in defendant demographics that is kind of what you might expect from the prior literature. Men are more likely to have new criminal activity. Younger defendants are less likely to have, or older defendants are less likely to have new criminal activity. The converse of that, younger offenders are more likely to. And Black defendants are actually more likely to have new criminal activity, which might have a lot to do with policing practices or enforcement practices in communities of color. Again, because most of these were drug offenses and public order or criminal traffic offenses. Those are enforcement-driven offenses, rather than say person offenses or property offenses, which are not enforcement driven. So what we might be picking up here is the effects of policing practices in communities of color. So the big takeaway, again, just to reiterate what we found before, was the reforms didn't really increase the percent or number of people who were released. It just changed how they were released. And the reforms did not result in an increase in new criminal activity. New criminal activity by those released remained stable at about 17%. New violent criminal activity by those released remained incredibly low at about 3%. So the reforms didn't have an impact on the criminal activity of those who released. It didn't change dramatically from before or after the reforms. Oh, somebody asked what is, that's a violation of bail bond, and it's whether or not they had a prior violation of bail bond, meaning that the last time they were released on bail, they didn't show up for court and got a violation. Oh, and Chris points out too, and this is important, right? Just because someone is charged with a new criminal activity, it doesn't mean they actually committed a new crime, right? Or that they didn't commit a new crime, right? So there's a lot of criminal activity that goes unreported. We also don't know whether or not people were actually convicted of the new criminal activity that they were charged with, right? Those cases may have been dismissed for a variety of reasons, and we don't follow that here either. Right. So the last thing we wanted to look at was there was an argument, and it continues to be an argument that bond court reforms in Cook County led to increases in crime rates in the city of Chicago. The one thing I want to point out is our study only followed people through 2019. We only followed crime rates through the beginning of 2020. It can't speak to whether or not bond court reform or bond court practices now are affecting crime rates. All we can say is that the reforms, after they went into place, we can talk about what kind of impact they had on crime rates then. At the individual level, what we just showed was that bond court reforms didn't change the likelihood that people would commit new criminal activity while on release. This section is then looking at what can we say about crime rates generally in the city of Chicago. This is a much more complex analysis, right? What it does, I'm going to give you the very brief version of it. What we're trying to do here is look at crime rates in Chicago, what we'd expect crime rates to be in Chicago based on historical trends in crime rates. What we'd expect them to be, and then we compare those to actual crime rates that we can observe after the reforms went into effect. And we try to account for as many things as we can around of what we might think affects crime rates, around monthly employment rates, arrest rates, some things about, that we know affect seasonality that affects the ability of people to, or likelihood of people to commit crimes out in public. And what we do is we kind of estimate those crime rates and look to see whether actual crime rates fell within those patterns. So we do this pre-reform period from October 2015 to August 2017, and we look at a post-reform period from October 2017 to August 2019. And we look at both the daily and the weekly counts of crimes to kind of get our estimates. And what did we find? So, whoops, I skipped one. So these are looking at crime rates, pre and post reforms for murder. These are the actual number of murders that were reported between August 16 and August 2017. October 2017 to August 2018, and then October 2018 to 2019. You can see that the number, this is just descriptive now, the number of murders is actually lower in both of the post-reform periods than it was in the pre-reform period. If we look at violent crime committed with a gun, we see the same pattern, that violent crime committed with a gun in the two post-reform years was lower than the number of violent crimes with the gun in the pre-reform years. And the same is true with overall violent crime, the actual aggregate number. To our analyses though, using this Bayesian time series and looking at expected crime rates and comparing it to actual crime rates, the way you read this is this circle at the top shows us the highest projected crime rate. This little square at the bottom shows you what the lowest projected crime rate would be, right? Our estimates give us a range of where we would expect the crime rate to be. And then this X is what the actual crime rate was during the pre and post periods for property crimes, violent index crimes, and violent index crimes with the gun. If the reforms led to higher crime rates, right, then this X would be above the circle. If it led to lower crime rates than what were expected, then this X would be below the square. What we find here is that the actual crime rates were within the range of what we would expected crime rates to be during this time period, based on historical patterns of criminal activity in the city of Chicago. So the big takeaway here is that the reforms also were not associated with an increase in crime in Chicago. right? They didn't markedly change the number or percentage of people released. They didn't result in an increase in new criminal activity by those released, and they weren't associated with an increase in crime in Chicago. The question for us is what's coming next, right? So there've been a lot of reforms in Cook County. So in 2017, the Illinois Supreme Court started the Commission on Pretrial Practices, and then they created an implementation task force in 2019. So for the last 4 years, roughly, the Illinois Supreme Court has been talking about pretrial reform in Illinois and trying to understand how pretrial reform can change. Last spring, Illinois passed the Safety, Accountability, Fairness, and Equity Today Act, better known as the Safety Act. The Safety Act abolishes cash bail in Illinois for the entire state. So while Cook County had this decision-making process where it was use preventive detention if you must, if not, a presumption of no cash bail, and then cash bail, but it's something someone could afford. The Safety Act does away with that last choice. Under the Safety Act, judges will have two options: either hold people in preventive detention or release them on their own recognizance. The idea behind it will do away with this disparate impact on poor people who are unable to post bail. The law also carves out a very narrow category of offenses that can be held pretrial. So there's a limited number of offenses that people can be charged with where they're even allowed to be held pretrial after the Safety Act goes into effect. A recent, again, as I said before, that counties can keep 1% of the bail that's posted by people. So this is clearly going to affect county revenue streams, right? Because if they can't keep that 10%, then it's going to decrease the amount of money that they can collect. A recent study by the Illinois Supreme Court found that counties would lose about $8 to $10 million annually in these avoided fees that they won't be able to collect. However, that's $8 to $10 million out of the $2.4 billion that Illinois counties spend on justice-related activities, right? It's 0.3% of the entire justice system budget in the state of Illinois. So it will have a minimal impact on their ability to meet their justice system needs. If the idea being that, right, we need this bail to support criminal justice activities, that's just not accurate. It only represents about 0.3% of their current annual budgets for justice-related stuff. What we don't know is how the reforms are going to impact pretrial release rates, right? Whether judges will start using preventive detention more or not, or whether, right, even with a narrow selection of categories of offenses that are eligible for detention, how it's going to be used. We don't know how it's going to affect jail populations. And we don't know how it's going to affect things like failure to appear rates or new criminal activity of those who are released. Dave and I have submitted a proposal to the National Institute of Justice to study bond court reform in Illinois to try to understand both the process of how counties are getting ready for this change in bond court practices, and then how it would affect not just local jails, but also state prison populations, sentencing practices in the state, as well as the pretrial release of those who are released pretrial. And we have a small grant that we got from the Arnold Foundation to kind of get an estimate, a very short-term estimate of how can we predict what the effect might be on bond court decision-making and jail populations, a project that we're starting this month. And we'll run through February of next year to try to estimate those impacts. But the local foundations and national foundations are very interested in bond court reform in Illinois. So there's going to be a lot of interest in this. The Safety Act doesn't go into effect until January of 2023, which is still about 15 months away. So that's a lot of time for people to question the potential impact of the law or to make changes to the law between now and then. So there's a lot of activity trying to ensure that it actually gets implemented as it was enacted. If you have any questions, Dave and I are always available to answer your questions. You can find us at at these email addresses. And if you're interested in the report that this presentation was based on, it was funded, as I said before, by the MacArthur Foundation as part of their Safety Justice Challenge Research Consortium Initiative. You can find our report here, and I think we can make that available to, you can download it from there, or we can send you this link later, I suppose, if you're interested in it. Yeah, and with that, I'll take any questions.
There's a question Marilyn has in the chat about drug offenses.
Oh, and the switch from bail to ROR. Yeah, part of our follow-up research was to look at specific offense categories and break down these different, the use of ROR, the use of the amount of bail, the release pretrial. Yeah, so if we go back, like drug offenders were much more likely to receive ROR, both pre and post the reforms. We'd have to go back and see which category of offenses had the largest impact. But to your point, like violent offenders and I'm sorry, people charged with violent offenses or weapons offenses were much less likely to get ROR. So these impacts are likely accruing to those charged with much lower or less serious offenses, drug crimes and property crimes. We also don't include misdemeanors here. So I'll say that too, one limitation of this study, it's only focused on people who go through felony bond court. So it's not looking at what happens in misdemeanor court to individuals, and some individuals can be held pretrial on misdemeanor charges. They're not included in this.
Don, can you go ahead and stop sharing your screen so we can, there you go, thanks. Other questions?
I have a quick follow-up question about the Reform Act. So does it take, because you had pointed out that the risk factor, that whole system seems to really be working. Is that taken into account versus just the crime that someone's charged with?
Yeah, so the Safety Act requires every county to adopt a pretrial risk assessment tool. Dave might be able to speak to this better since he's on the Supreme Court Commission, but it's being developed by, they're not using the same PSA, which the Cook County is currently using. They're adopting a new risk assessment tool developed specifically for Illinois, but all counties are supposed to use that to set conditions of release. So while the reforms say that monetary bail can't be imposed, judges can impose conditions of release requiring individuals to abide by certain things. So the pretrial risk assessment tool is intended to guide the judge in imposing those conditions. The way the reforms work is a prosecutor has to make a motion to hold somebody pretrial if they want to. There's a limited set of offenses for which they can make that motion. And when they do, it then goes before a judge, and there's a hearing to determine whether or not the person will be held or released in the conditions of release.
And then I had one other quick question. So with when you were looking at bail and the amount of money that ended up not being charged in different communities, and I might have missed this, but were you able to compare like how much was actually collected versus how much was potentially charged?
Those were looking only at the amount imposed.
Okay.
We didn't break it down then by how much is actually paid. The data we got from Cook County is incredibly complicated, and the jail data and the court data is not meant to talk to each other. So determining who was released and when they released is incredibly complicated. We were able to tell, for example, how much bail someone had imposed. It was very difficult to determine how much exactly they paid. So no, we don't. We can estimate how much was saved by simply avoiding, if they avoided the entire cost or had to pay the entire cost of the bond amount, bail amount.
Thanks.
Dave's weighing in from his jury duty here. Donna, if you want to speak or summarize what Dave's sharing with us here.
Sorry, I'm back now. Oh yeah, so because your question was about the risk assessment tool, and yeah, Dave's just pointing out that the Safety Act allows for the use of a risk assessment tool, but it doesn't require it to be the basis of any decision. Nonetheless, the state is creating a statewide risk assessment tool that's intended to be used to make those decisions. Oh yeah, the other thing that we are looking at or we propose to look at in the NIJ proposal is to look at the increased use of community-based supervision for those on pretrial status. Not everybody gets pretrial supervision if released pretrial. The question here is, now that judges can't impose monetary bond and it's more difficult to hold people pretrial, will there be an increased use of pretrial community-based supervision for those who are on pretrial status? So there is some potential for a net widening effect, that while people will be released, they will be supervised more in the community during that release, which may lead to increased failure while on pretrial release, right? If they violate the conditions of the release and they're being supervised by pretrial services.
Christine? You got to unmute yourself.
Good idea to unmute. I was thinking back to looking at the judge's implementation of the new policy, and how, and how the new, how there was a decrease that happened over time. And I thought that was really interesting. And just some of the work we're doing in DV court about the impact of changes of policy on judges actually complying with the policy. I mean, it just struck me. I don't know if there's any more work that you have done or that you know of that looks at that.
We haven't done any additional work on that, and to our knowledge, no one else has looked at bond court decision making in the last 18 months, right? So COVID really changed things anyway. Bond court is turned upside down like everything else. So I don't know that looking at 2020 through the middle of 2021 would tell you much about what's happening. But I like your point is well taken. I think it's interesting too, if we go back to that chart, the use of ROR increased going towards the reform. Right, so judges were already it seems there was probably talk that the reforms were coming, and were changing their practices in anticipation of the reforms in bond court. And then it spiked right after the reforms, and then decreased over time. So there is some change in judicial behavior both before and after the reforms in relation to them. And we have not explored why that change happened. Why judges, over time were decreasing their use of ROR and increasing their use of monetary bail. But it'd be interesting to see how that persisted, and how now that bond court's kind of coming back, what is happening now in bond court.
Yeah, and do you know what the tenure is of judges in bond court? Are they in for a long time, or is there a real change as they're moved from court to court? And
I don't know. I wonder if someone else can speak to that, if that's an assignment that judges hold for a long time. Dave's not going to weigh in.
While we all wait on Dave.
No, he might know. I like Dave's point here is good. I mean, they're right. We don't know if these reforms have been dismantled over time. Right, that whether judges have reverted back to practices they have, particularly given the media attention now about homicides and shootings in Chicago, the persistent arguments by the mayor and the superintendent of police in Chicago saying that bond court reforms are the reason for upticks in shootings and homicides. Judges, are part of the community too, and they may be hearing that and have changed their practices. We don't know how their practices have changed in response to that. but to Dave's point, I guess that argument would be even more misplaced if in fact judges have decreased their use of ROR and increased the use of monetary bail over the last 18 months.
Yeah, Chris has a question in there. Maybe Chris, you want to, if you're able to, just unmute yourself. Otherwise, I'll give Don a chance to read through here. Your choice.
Yeah, so I was just wondering, when I worked at a pretrial department in Cincinnati, we conducted interviews and investigations of all of the arrestees that came into the jail, and then provided that information to the bond judge the next morning so that the judge had, in theory, a lot of information to then make bail decisions. And I was just wondering if Cook County has a similar process, and or what information do the bond judges have to make an informed decision?
Yeah, our understanding is that all bond court judges in Cook County have the pretrial, felony bond court judges in Cook County have the pretrial risk assessment scores. And that is done by pretrial services through the PSA in Cook County is largely based on criminal history. And I don't know if they have a more elaborate interview that they do with defendants that is also provided to the judge, but the judge does have the pretrial risk assessment score at the time that they make decisions. And there is a pretrial department that's within the chief judge's office that supervises some people while on pretrial release. Yes, as Dave points out, we did find that the risk assessment score did influence the judge's decision, right? It was predictive of both the initial bond court decision and whether or not an individual was released pre-trial.
Other questions?
I have a question. I'm just curious what you think with the Safety Act. So if it's going to the extremes, either ROR or you're held, and before they kind of had the middle option of a lower monetary bond. And you said that it's not really that many eventually released at the end. Do you think you'll see like they'll kind of find that same number again, or just hypothesizing, whatever you think?
So there is so as I said, the number of the offenses for which someone can be held pre-trial, well, it's a debate whether it's a very narrow number of offenses or whether it's a pretty broad spectrum of offenses. So that is a debate that's currently happening. Some people who read the law saying like, no, there is a very limited set of offenses for which anybody can be held pre-trial. So the number of people held pre-trial should go way down in Illinois because it's a very narrow set. Others have read the law to say, no, there's a lot of discretion built into this and that prosecutors can make a motion to hold someone pre-trial, regardless of the offense, right? For almost all offenses, felony offenses, the argument goes. So one of the things we're trying to do in this research we're doing over the next 6 months is, well, can we estimate that just based on who's currently coming through bond court and who's being held pre-trial right now in county jails? Can we say of those people who go through bond court right now with this very like conservative definition, this very narrow definition, right? These are the people who could be held pre-trial and these are the people who released with this kind of broader definition. So we're trying to do that now. That's the hypothesis are hard to come up with because there's a real disagreement currently about whether this reform will affect a lot of people or not many people at all. I don't know if that answered your question. I'm sorry. But I think the problem is there's a lot of debate around what this law actually says that people are going to have to clarify between now and January of 2023 when it goes into effect. I think, oh, Dave might jump into some initial analyses in Winnebago County. Dave can correct me if I'm wrong, showed that this would affect very few people that are currently held in jail. That their practices right now align fairly closely with the reforms anyway, that the people who are held in the jail tend to be people who, the narrow sliver of people who could be held after the reforms go into effect. So there's some initial kind of anecdotal stuff in the county showing that this might not impact jail populations as much as we think. Oh, sorry, it was another county to be named, to remain nameless, Dave said. Sorry.
Rhymes with Winnebago. Anyway, thanks. And then Olivia is on the shuttle and so can't weigh in voice, but you can see her comment there, Don, about, and to your question, I think Christine, who asked it about how long judges stay on bond court. So direct everyone's attention there. And Olivia, you get extra points for attending the seminar and being on the shuttle, as long as you're not driving the shuttle, in which case we got bigger issues. Other questions for Don and Dave? Marilyn?
Oops, yeah. Are you getting further media attention for this? Are advocacy groups picking up on this kind of as you throw this, well, you don't throw it, but as you place this information in the public realm, I'm just curious what's going on now.
Yeah, it got a lot of attention last fall when it came out, and through the winter. It even had legs in it late into the spring as the superintendent of police and the mayor continued to argue about bail reform and its effect on crime. It seems to come up every now and then. It did come up over the summer, and I'm trying to recall in what context, but there are, as people start to think about bail reform in other jurisdictions, they are pointing to this as an example of how in one large urban jurisdiction, the bail reform did not lead to more crime. So advocacy groups have picked up on it. I'm sure they use it. As we said before, a lot of nonprofits are very interested in what's going to happen in Illinois. So they're bringing attention not just to this report, but to other reports that show that bond court reform could have a significant impact. Oh yeah, Dave said city council hearings through the summer. It also came up. It also came up there. But yeah, I think it has legs. It's there are only a handful of large-scale bond court reform evaluations in urban settings. So it's one of a few that you can point to that shows how these reforms, what kind of impact these reforms can really have.
Jill?
Yeah, I'm assuming all of your analyses of the various factors that even after you pulled everything out on the left and the right, those bar charts, that you were holding everything else constant and looking at the impact of individual factors, and so persisting at the end there of gender and race. There's still an effect for maleness and blackness, and that those would even holding then constant the effect of the predictive value of the types of crime and whatever those statistics are that predict the possibility of criminal offense again and so forth. Still, maleness and blackness have significant effects held alone. That seems to be important and show bias on the part of judges that persists. I would think that's something that needs to be addressed. Persistently, constantly, over and over again. Are there ways that you? I mean, obviously, in your presentation, you did highlight that. Are the not-for-profits and the advocacy groups picking up on that and running with it as they should?
I would think so. Yeah, the effects of sex and age are two that are persistent across all studies, right? They show that men and younger men tend to get longer prison sentences. They are more likely to get a custodial sentence. They're more likely to receive monetary bail in our analyses too. The effects of race are interesting in this, in that Black defendants post reforms were more likely to get released on their own recognizance than white defendants, but were less likely to be released from jail. And when we showed this to the chief judge's office, they were curious about that too. And the one response we got from someone within their office was that while judges have reduced monetary bail amounts, they still have not, they're not sensitive to the economic disparities that exist across communities of color in Chicago, right? So that while $3,000 sounds reasonable to a judge, perhaps in the setting of bail, that is still an unreasonable amount for a Black defendant in Cook County. That those, right, the judge is supposed to set bail at an amount that a defendant can afford, and clearly there are differences in the assessment of what someone can afford, and those seem to be different for the Black community than the white community. Yeah, folks are paying attention to that. I think the idea, the elimination of cash bail should do away with that, right? Because now we're not setting a bail amount at a point that's beyond the reach of some people. It'll be curious to see, once the only decision judges have is detain or not detain, what kind of effect race might have on those, or what kind of effect sex or age might have at that. I'll say this: the persistence of the effect of being male on outcomes is consistent across all criminal justice outcomes, whether it be pretrial detention or sentencing or prosecution or conviction or custodial sentence.
Well, and male and race, as I understood your charts.
Yep.
Yeah. Just not right. Not fair.
Thanks, Jill. Other questions? Teresa, you want to wrap us up and give Don and that always talkative Dave Olson final word?
Yeah, any final thoughts, Dave and Don, that you'd like to share before we conclude?
Nope, I'd just like to thank you guys for giving us the opportunity to talk about this work. We think it's important. We think it's gonna, the reforms that are coming soon to Illinois, I think will be profound. So I think we're glad to be part of the conversation. Thanks.
Yeah, thank you so much for being here. Thank you all for joining. We'll be doing this again next week. So please join as you are able, and thanks, and have a great afternoon.